Hi, welcome to Introduction to Contract Law. My name is Rachel Bornstein. Whether you're studying to actually practice as a lawyer or use the law to help you on your day-to-day lives, contracts are something you must know. When you start contracts, you want to know how to dot your I's and cross your T's. We come across contracts day to day. Let's look at a few examples. Let's say you've decided to do renovations on your house and you close with the contractor. Between the two of you, you work out the materials, the layout, the plans, cost. You've signed a contract and you thought that you had thought of everything. Unfortunately, you were missing just one clause: a time. Since there was no clause stating how long the work would take, you thought you'd be back in your home in 2 weeks. But 2 months later, there's no chance in sight. The contractor has found a loophole, and a loophole is an ambiguity in the contract which allows one of the parties to avoid completion of his or her part of the agreement. And when do you see contracts in English on a day-to-day basis? I assume that you at some point need to upgrade your program or download something new. Well, when you do so, you actually sign a contract. There are 2 kinds of contracts I'll mention now. The first is called click wrap. And when you do so, you have 2 lines: Microsoft Service Agreement in this example, Microsoft Online Privacy Statement. Have you ever taken the time to actually read what those contracts say? And in small writing it says, to accept the terms of the service, I accept. Clicking I accept means that you agree. Again, click without thinking. Then there are the browse wrap agreements. The following website is for changing the format of a file. You may choose to change one from MP4 to another kind of format, and there are a few steps to take. Step 1, give the source of your file. No problem. Step 2, what would you like to convert it to? And step 3, your email address to get the converted file. Up until now, no problems at all. But then comes step 4. In a browse wrap agreement, you may not even realize you've signed a contract. Look at the very, very small writing in the brackets. By pushing the button Convert, you have agreed to the terms of the contract. Did you even notice that there was a contract there in the first place? There are contracts everywhere. Beware. They're there on a daily basis. Many of them are in English. Learn to read the small print. That is the end of the introduction. What we'll be beginning now is learning actual terminology in English related to contracts. What you're learning today is contract law, which you've probably already learned in Hebrew. But today, you are being exposed to the same terms in English. So, what is a contract? The legal definition is a mutual agreement between 2 or more parties which can be enforced in court. There are different kinds of contracts: written, oral, partly written, and partly oral. There is some debate regarding oral contracts in land. Let's look on to more terms. We talk about a promise, a statement that something will or will not happen in the future. I can promise that if you do your homework and study, you will succeed. And a contract is an agreement based on a promise, and that can be upheld in court. Another important term is consideration. This is not to be confused with being polite in normal English. Consideration is a legal term that we use that something of value, such as an act or return promise, a benefit, or forbearance, are given. We have the parties in a contract. Who are the parties in a contract? First we have the offerer, and then we have the offeree. The offeror is the person who actually proposes the agreement. The offeree is the one who agrees to the proposal. How do you remember which one is which? Think of employer and employee. The employer is the one who proposes and offers the job. The employee is the one who accepts it. Easy enough to remember. I'd like to remind you and point out that any words that you see in color, in bold, or underlined are contract vocabulary words that you should be aware of and study. In order for a contract to be legally binding, there must be an offer and acceptance. Both parties must enter the contract willingly, without undue force or coercion. As a teacher, I am in a place of power, and it would not be wise for me to get into a contract with you. If I did, I would be putting you in an unfair position, and you could claim that you have been forced into this position. It must be in good faith. We'll be explaining that soon. Most countries also require consideration, which I've mentioned before. In other words, let's sum up. An agreement means an offer has been made and accepted. Both parties must show they have entered this agreement willingly. And if all of the elements are incorporated, the contract will be formed. So what are those elements? The serious intention of the offerer. Do I really have something to sell? Or am I just joking and playing around? Clear and definite terms, expressed or implied. Let's go back to the renovations on the house. If we had not set out in advance what we want done in the contract, then we'll have difficulties implementing it. Then we have communication to the offeree, either directly or through a third party or agent. Imagine you want to sell your house. I would guess that you would prefer to take an agent who understands real estate law and in order to do the negotiations for you. That would be an example of third party. In the second part of this lecture, we'll be looking at a direct offer. Let's look at something even more basic. Ophir has decided he wants to sell his car. So how does he do it? He puts up a notice with details of the car and expresses the price directly on the notice. Ms. Walker comes along after walking for hours and sees that this car is up for sale. She contacts Ophir, looks at the car, has it inspected, and checks the price. If she agrees to his offer and accepts it, a contract has been made. This is a bilateral contract. A bilateral contract is one where both parties make promises for future performance. Ophir promises to sell the car. Ms. Walker promises to pay the price. But what happens if the deal falls through? Then we may say there has been a breach of contract. If one party fails to complete their side, there has been breach and they may be taken to court. I'd like to remind you, we talk about breach of contract, we talk about violation of a law or statute, and we talk about copyright infringement. All of these words mean the same thing, but in a different context. There is also a unilateral contract. And a unilateral contract is one in which one party makes a promise for future and the others must perform in full order to accept the offer. So what does that mean? Let's look at an example. You are a student on campus and you have a computer with all of your notes, all of your contacts, your life, and you lose it. What can you do? You put up a notice on campus offering a cash reward for the person who returns it to you. The person who returns it is under no obligation to do so. But if they do, it is your job to pay the money. You've actually started a contract, although unilateral. We speak of good faith. A person entering a contract expects someone to enter it in good faith. Be honest. Tell the truth. You have a job to do. You have an obligation. You must fulfill it. There must be reasonable standards. I will not go into that now. And absence of intent to defraud. In other words, you are not out to cheat the other party. Mediation and arbitration. Sometimes, if there may be a breach of contract, you don't want to rush to court and incur the costs. So we have alternate solutions. We can go for mediation, in which a neutral third party gets involved, listens to both sides, and gives a few suggestions how this issue may be solved. In this case, the suggestions of the mediator do not have to be adopted by the parties, and they can go to court. On the other hand, you may choose to go for arbitration and even enter a binding arbitration clause into the contract. What the arbitrator says is legally binding. The word and decision of the arbitrator is legally binding, and you cannot go back. Therefore, many people, in cases such as those of renovations, have a clause entered from the beginning saying that if there is a disagreement, we will go to an arbitrator in order to solve our differences. In case of breach, the court may enforce the contract after it has decided the contract is valid. And in this case, the law provides remedies in the form of damages, money, or specific performance. Somebody will have to do something that was stated in the contract. Well, how much can you claim? When a person claims for damages, they want to get back to the point that they were originally before the contract was signed. Let's imagine, months in advance, you book a ticket and book a hotel for a conference that will be taking place. You've paid the deposit, booked airline tickets, planned everything. You know that you must do so because there will not be one hotel room available. Months later, the day comes. You fly out, arrive at the hotel, only to be told, "Sorry, we have no evidence of your booking. And no, there are no more places for you to stay over this conference." Well, what could you get back? I can assume that as lawyers-to-be, you will have some very creative suggestions. Damages in contracts. When we talk about damages in contract law, we have a few specific kinds for contracts. We have incidental damages, and in that case, you may find that something has happened as a result of the other party's breach, and therefore you will ask to get compensation. Here's an example. George has ordered a new Ferrari through a car salesman, and while the Ferrari is being shipped overseas, George gets over his midlife crisis and decides to buy a family car. The poor salesman has had to pay for shipment of the car, receiving it, going through the entire process when it comes into the country, and shipping it back out. He can sue for breach of contract and incidental damages. We also have liquidated damages in contract law. Liquidated damages is an amount agreed upon at the beginning of the contract when they decide in advance what will be given as compensation in case there is breach. For example, you may put a clause into your contract that you would like the contractor to pay a fine of $100 for every day he is late with his work. What is a void contract? A void contract is one that has no legal effect. In essence, it's as if no contract has been formed in the first place. A contract may also be declared as void by the court if it is somehow defective, against public policy, or illegal. So, if two drug dealers have made a deal and somehow it didn't go through, it would not be wise for them to go to court, since in actual fact this contract was illegal and therefore, in the eyes of the law, void. We're getting towards the end of session 1. We're looking at points that will help us out in session 2. We talk about void contracts as a defense. A valid contract may be that the party who broke the contract was actually a victim. Something unfair happened and he shouldn't have been made to complete the transaction or be held to do the contract, fulfill the contract. If the court considers that unfairness has existed, it may declare that the contract is void and did not exist. Let's look at an example. Sunny and Sammy have signed a contract. Sunny has no clue what he has done since he was up to his 5th vodka at the time of signing the contract. Sunny can avoid the contract claiming he didn't know what he was signing as long as it was clear to Sammy, the other party, that Sunny was drunk at the time. And what about force majeure, an act of God? In this case, an event can be neither anticipated nor controlled. Acts of nature, a storm or tornado, or acts of people. You had agreed to come to a certain destination by a certain hour. Traffic jam, strike. And no, I'm sorry, I can't come to sign the contract because I've been called to Miluim in case of war. That's how life goes. Food for thought. Let's just end with a few ideas. When you buy a plane ticket, have you actually signed a bilateral contract? Yes or no? And under what circumstances could you claim compensation if your flight does not reach its destination on time? And by law, can you? Here we will end part 1. In part 2, we will look at an actual example of breach of contract law. Thank you.